Welcome to the conclusion of Protecting Trade Secrets. As always, I'm Professor Seth C. Oranburg. We've reached the end of our journey. You've learned what trade secrets are, how they're defined, and why they're unique within the intellectual property landscape. You've inventoried and classified secrets, valued them strategically, and assessed the risks they face. You've studied internal and external risk mitigation, enforcement strategies, and how to build comprehensive trade secret protection plans that adapt and endure. But before we close, I want to step back, not to review every detail you've covered, but to reflect on three things: where we've been, what makes trade secret law essential, and where you go from here. This isn't a summary lecture. You've done the work. You know the material. This is a moment to consolidate, contextualize, and consider what trade secret protection means, not just as legal doctrine, but as strategic discipline, economic enabler, and competitive advantage. Let's begin with the journey we've taken together. We started at the foundation. Module 1 introduced trade secret law's history, its place within intellectual property, and the three essential elements: information, independent economic value from secrecy, and reasonable efforts. You learned that trade secrets reward diligence, not entitlement. Protection isn't automatic. It's earned through continuous, systematic effort. Module 2 moved from theory to practice: how to identify trade secrets through audits, how to classify them by type and value, and how to build inventories that capture technical secrets, business secrets, and hybrid assets. You learned that you can't protect what you don't know exists, and that identification is the foundation for everything that follows. Module 3 introduced valuation and risk assessment: how to calculate what secrets are worth using, cost, market, and income approaches, and how to map threats through risk matrices that balance likelihood and impact. You learned that not all secrets deserve equal protection, and that strategic resource allocation depends on knowing what matters most. Module 4 addressed internal risk mitigation, employee agreements, training, access controls, and culture. You explored JML protocols, joiners, movers, leavers, and learned that contracts without training fail, that training without enforcement decays, and that culture is what makes protection durable when no one is watching. Module 5 turned to external risk: third-party, non-disclosure agreements, vendor due diligence, M&A disclosure protocols, and how to share secrets without destroying them. You studied tiered classification, clean teams, staged disclosure, and how to balance collaboration with confidentiality in transactions where secrets must cross organizational boundaries. Module 6 covered enforcement: proving misappropriation under UTSA and DTSA, obtaining injunctive relief, calculating damages, and making strategic choices. You learned that injunctions protect exclusivity, damages compensate harm, and criminal enforcement under the Economic Espionage Act addresses the most egregious theft. Module 7 synthesized everything into a comprehensive framework: the 6 pillars of trade secret protection, how to implement them through accountability and metrics, how to sustain them through ongoing governance, and how network theory explains when trade secret law adds unique value beyond contracts and norms. Each module built on the last. Doctrine shaped strategy, strategy guided operations, and operations fed back into legal protection, because courts evaluate reasonable efforts holistically, not module by module. The arc wasn't just doctrinal, it was practical and strategic, preparing you to advise clients, build protection systems, and enforce rights in a world where information is mobile, threats are evolving, and secrecy must be maintained across departments, vendors, jurisdictions, and years. Throughout this course, 3 ideas recurred, threading through every module, every case, every strategic choice. They're worth restating explicitly because they define what trade secret law is and what it demands. First, trade secret law rewards diligence, not entitlement. Unlike patents, which grant rights automatically upon issuance, or copyrights, which arise upon fixation, trade secrets exist only as long as you protect them. The law doesn't create your rights. It recognizes them if you've done the work. Reasonable efforts aren't a formality. They're the price of admission. This principle has profound implications. It means that trade secret protection is never finished. You can't draft policies once and assume they'll work forever. You can't train employees in year one and skip year two. You can't audit access controls in 2020 and trust they're still adequate in 2025. The law demands ongoing, visible, systematic diligence, because secrets that aren't actively guarded aren't legally protectable. Courts evaluate this diligence through the reasonable effort standard, a flexible, context-dependent inquiry that looks at what you did, how consistently you did it, and whether your actions match the value and risk of the information. There's no checklist, no safe harbor, just a pattern of evidence that proves you treated secrecy as a priority. Second, protection is a system, not a checklist. Trade secret protection isn't a collection of isolated practices. Non-disclosure agreements here, training there, access controls somewhere else. It's an integrated system where each component reinforces the others. Identification feeds risk assessment. You can't assess threats to secrets you haven't inventoried. Valuation shapes mitigation. You can't allocate resources intelligently without knowing what's worth protecting. Internal controls enable external disclosure. You can't share secrets safely with vendors if you don't protect them internally. Documentation supports enforcement. Every policy, training log, NDA signature, and audit report becomes evidence when litigation arrives. And governance sustains all of it. Without periodic review, without cross-functional accountability, without adaptation to change, even well-designed systems decay. The 6 pillars: identification, valuation, internal mitigation, external mitigation, enforcement readiness, and governance aren't sequential steps. They're interconnected elements of a living framework that evolves with your business. Third, context determines strategy. Trade secret law doesn't operate in a vacuum. What works in a dense network, Silicon Valley, Hollywood, venture capital, may fail in a sparse network of one-time transactions, cross-border vendors, or non-competing industries. What makes sense for a crown jewel secret, your most valuable, highest-risk asset, doesn't make sense for routine business information. Strategic counsel requires understanding when trade secret law matters, why it matters, and how much protection is proportionate. In dense networks, invest in reputation and relationships. In sparse networks, invest in legal protections. For crown jewels, implement Tier 1 controls, encryption, limited access, tailored non-disclosure agreements, continuous monitoring. For routine secrets, baseline measures suffice. Context also shapes enforcement choices. Property rules, injunctions that stop use. Work when secrets remain intact and harm is irreparable. Liability rules, damages that compensate loss. Work when secrets are already compromised or when forced exchange serves broader interests. The Calabrese-Melamed framework we studied isn't abstract theory. It's a practical tool for deciding when to seek exclusivity and when to price harm. These 3 ideas, diligence, systems thinking, and context-sensitive strategy, distinguish sophisticated trade secret counsel from those who treat protection as a compliance exercise. So why does trade secret law matter? Why not just rely on patents, copyrights, contracts, and torts? Because trade secrets do something the other IP regimes can't. They protect competitive advantage through secrecy, forever if maintained. Patents require public disclosure. You file an application, describe your invention, and in exchange, the government grants you a time-limited monopoly, typically 20 years. After that, the knowledge enters the public domain. Patents are powerful, but they're temporary, and they demand that you teach the world how your invention works. Trade secrets are the opposite. They protect knowledge by keeping it hidden. No registration, no disclosure, no fixed term. As long as the information remains secret and provides competitive value, protection continues. The Coca-Cola formula has been a trade secret for over a century. The KFC recipe, the Google search algorithm, the Netflix recommendation engine, all trade secrets, all protected through ongoing secrecy, not through time-limited government grants. This makes trade secrets uniquely suited to certain kinds of innovation, processes that can't be reverse engineered from the final product. business strategies that competitors can't observe, R&D that hasn't yet matured into patentable inventions, and know-how that provides value precisely because it's not generally known. But trade secrets aren't just an alternative to patents. They're often a complement. Companies patent core technologies while keeping refinements, negative data, and manufacturing optimization secret. They copyright software while protecting source code and algorithms as trade secrets. They trademark brands while keeping formulas confidential. Trade secrets also do something contracts can't. They create in rem rights that bind third parties, not just contracting parties. If you sign an NDA with me and share my secret with a competitor, I can sue you for breach, but I may have no claim against the competitor. Trade secret law solves this by imposing liability on anyone who misappropriates information, even without privity. This is why trade secret law is essential in sparse networks. One-time vendor deals, cross-border transactions, employee departures to non-competitors. Contracts create personal obligations. Trade secrets create enforceable rights that follow the information wherever it goes. And here's the deeper truth. Trade secrets enable innovation. They allow companies to invest in R&D without immediately disclosing results to competitors. They enable startup ecosystems, venture capital, controlled collaboration, and open innovation. They protect the knowledge that makes patents possible, the algorithms that power software, and the customer insights that drive strategy. Without trade secret law, firms would either overinvest in physical security, wasteful, socially harmful self-help, or underinvest in innovation, knowing that anything they develop could be stolen without recourse. Trade secret law isn't just doctrine. It's economic infrastructure. It's what makes knowledge-based competition possible. So what do you do with everything you've learned? If you're a student, apply the 6-pillar framework to real clients. Conduct trade secret audits, build inventories, draft protection plans, advise on enforcement. Remember that trade secret law rewards systems thinking. So don't just memorize doctrine. Learn to diagnose problems, design solutions, and adapt as circumstances change. If you're a practitioner, audit your current practices. Do your clients have inventories, risk matrices, JML protocols, governance committees? If not, start building. If yes, review whether they're maintained, updated, and aligned with current threats. Remember that courts don't reward intentions, they reward evidence. So document everything. For everyone, stay current. Trade secret law is evolving. The DTSA is still young. Courts are refining its application, especially around whistleblower immunity, employment restrictions, and extraterritorial reach. AI and generative models are creating novel risks. Inadvertent disclosure through cloud tools, questions about whether AI-generated outputs are protectable, and the tension between secrecy and explainability. Globalization is complicating enforcement, cross-border misappropriation, legal asymmetries, and diverging standards for what counts as reasonable efforts. This field moves fast. What was defensible yesterday may be inadequate tomorrow. Keep learning. Keep adapting. And remember that trade secret protection isn't a project. It's a discipline. Trade secrets aren't just legal protections. They're strategic assets. They're what allow companies to compete on knowledge, not just on products. They're what enable innovation without immediate disclosure. They're what make collaboration possible in a world where trust is scarce and information moves fast. But they're also fragile. They exist only as long as you protect them. They disappear the moment secrecy is lost. And they're enforced only when courts see that you've treated them seriously, systematically, continuously, and proportionately. The work you've learned in this course, building systems, documenting efforts, enforcing diligently, adapting continuously, is what makes innovation possible. Courts don't protect secrets. You protect secrets. Courts protect you if you've done the work. So take what you've learned. Build protection plans that last. Advise clients who understand that secrecy is a discipline, not a formality. And enforce rights in ways that balance exclusivity with competition, innovation with mobility, and proprietary advantage with public accountability. Trade secret law rewards those who act deliberately, document thoroughly, and adapt continuously. It's hard work, but it's work that matters, because without it, the knowledge economy collapses. Thank you for investing your time in this course. Thank you for engaging with the doctrine, the strategy, and the practical realities of protecting trade secrets. And thank you for committing to build systems that don't just comply with the law, but embody its principles. Good luck. Stay vigilant. And remember, trade secret protection isn't a project. It's a discipline.